Think you know where your assets will go when you're no longer here? Well, stick around, you might be surprised. Hey there folks, welcome to Everything Estate Planning. I'm Jim from Elm Legal Services, and today we're exploring an essential topic, last will and testaments. Now in this video we'll break down the complexities of estate planning, focusing specifically on last will and testaments. So whether you're planning ahead or you're just curious, you've come to the right place. Before we begin, let's outline the key learning goals for today's video. By the end of this video, you will understand the basics of a will, what a last will and testament is, and why it's a crucial part of any estate plan. Know the essential components. What elements are included in a will, such as asset distribution and guardianship decisions. Recognize the importance of having a will. Understand the potential consequences of not having a valid last will and testament. Understand the rules of intestacy. Oh, that's a biggie. Know how your assets will be distributed in the absence of a last will and testament. And I'm going to debunk some common myths. Understand some common misconceptions about wills and why they are essential for everyone, regardless of age or wealth. So let's start with the basics. What exactly is a last will and testament? Well, it's a fancy term for a will. A legal document that spells out how your stuff, money, possessions, gets divided up after you're gone. A will also covers who takes care of your dependents, such as kids or anyone else who depends upon you. So what goes into a will? It's not just about who gets your money and things, though that is a very, very big part of a last will and testament. A will covers several key areas. Distribution of assets. Now your will tells everyone who gets what. Your home, your car, your investments, and even your personal keepsakes. You can get super specific, ensuring your cherished items go to the right people. Do you want your niece to have that vintage record collection, or your best friend to keep your prized teapot? You can spell it all out exactly as you wish. Now there's guardianship decision. Do you have kids that are under 18? Your will lets you choose who takes care of them. This avoids family fights and ensures your kids are looked after the way you want. You know your family best, and this is your chance to make sure your kids are raised by someone who shares your values and parenting style. Funeral arrangements. Yes, tough to think about, but your will can outline your funeral preferences, easing the burden on your family during a very, very tough time. You can specify if you want a simple ceremony or something a little bit more elaborate, whether you prefer a burial or a cremation, and any other personal touches that may matter to you specifically. Additional considerations. Beyond these major areas, your will can address a few other important matters. For instance, you can appoint executors. Now these are people you trust to carry out the instructions within your will. You can also make provisions for any pets, ensuring they go to a loving home. Additionally, if you have digital assets like social media accounts or online subscriptions or cryptocurrency, you can include instructions for managing those as well. Now, let's talk about why having a will is so important. Here's what happens if you don't have a valid last will and testament. 1. Distribution according to laws. Your hard-earned assets get divided based on impersonal legal formulas. Now these are called the rules of intestacy. These rules don't care about your wishes or family dynamics and might not suit your needs. Imagine your possessions and savings just being distributed in a way that doesn't honour your intentions or reflect the special relationships you've built up over your lifetime. It's like having strangers decide who gets what from your life's work. 2. Guardianship conflicts. Without a will, the court decides who raises your kids, which can be a long and stressful process. Your preferred caregiver might not be recognised without a last will and testament. You want your kids to be with someone you trust and who shares your values. But without a last will and testament, there's no guarantee that the court will choose that particular person. This uncertainty can lead to family disputes and emotional strain during an already very difficult time. 3. Probate delays and expenses. No will typically means a more complicated and expensive probate process, reducing your loved one's inheritance and adding stress during an already very difficult time. When there's no clear guidance from a will, the process of settling your estate, known as probate, can drag on and cost more in legal fees. This can eat into the inheritance you intended for your family and loved ones, creating additional financial and emotional burdens. By having a will, you can avoid these implications and leave a clear set of instructions that reflect your wishes, ensuring your loved ones are taken care of the way you want. It's a practical and loving act that can spare your family unnecessary stress and conflict. Now, we briefly touched upon the rules of intestacy, but how exactly might these impact the distribution of your estate? The rules of intestacy dictate how an estate of a person who dies without a will is distributed. Now, the rules prioritise the deceased close relatives, distributing the estate according to a strict hierarchy. Please remember that these rules apply only to England and Wales. Different rules will apply if you live elsewhere, so please check before making any decisions based on the following information. So without further ado, here's a detailed breakdown of how these rules work. You will need to grab a cup of tea because they are fairly complex. If you have a spouse or civil partner but no kids or other direct descendants, the entire estate passes to the surviving spouse or civil partner. If you do have a spouse or civil partner and kids or other descendants, your spouse or civil partner receive all personal belongings, also known as chattels, the first 322,000 of the estate. Now, this is actually called or referred to as the statutory legacy, and this may be subject to change based on inflation or legal updates. Now, half of the remaining estate will go to your spouse, and the other half of the estate is divided equally among your kids. If a child has predeceased but has left descendants, those descendants will inherit that share that would have gone to their parent. Think of grandkids. If you have children, including adopted, but excluding stepchildren, unless actually they've been legally adopted, but no surviving spouse or civil partner, the entire estate is divided equally among your kids. If any child has predeceased, their share is divided equally among their descendants. Again, your grandchildren. If there is no surviving spouse, civil partner, or children, the estate is passed on to other family members in the following order of priority. Now, you would assume, and you would be correct, the parents are at the top of that. Then you have siblings or their children if they have died before the deceased, think grandchildren. Half siblings or their children if they have died before the deceased, grandparents. Uncles and aunts or their children if they have died before the deceased. You've got half uncles and aunts or their kids if they have died before the deceased. If there are no surviving relatives, the estate will pass to the Crown. In English and Welsh law, when an estate passes to the Crown, it means that no living relatives or heirs can legally be identified or found to inherit the estate under the rules of intestacy. Now, this process is known as bona vacantia, which is a Latin term meaning ownerless goods. In this circumstance, the Crown refers to the legal entity that represents the government and the state, not specifically to the reigning monarch. Typically, an estate that passes to the Crown passes to the government, generally to benefit public funds. Kind of the exception to this is if the deceased was a resident of the Duchy of Cornwall or the Duchy of Lancaster, in which case the estate will pass directly into these institutions. Exploring this then further, then let's look at who won't inherit under these rules. Unmarried partners, people who were not married or in a civil partnership with the deceased at the time of death, do not inherit under the rules of intestacy. Now, this includes partners in long-term relationships or cohabiting couples, no matter how long they've been living together. Stepchildren. Stepchildren do not inherit under the rules of intestacy unless they were legally adopted by the deceased. Being a stepchild without formal legal adoption does not confer rights of inheritance under these rules. Friends. Friends of the deceased are not recognised as heirs under the rules of intestacy, regardless of the closeness or length of that particular friendship. Foster children. Foster children, like stepchildren, do not automatically inherit unless they were formally adopted by the deceased. Simply being under the care of the deceased as a foster child does not entitle them to an inheritance. In-laws. Relatives by marriage other than spouses or civil partners, for example, brother-in-law, sister-in-law, are not entitled to inherit under the rules of intestacy. Then we have charities or organisations. Charitable organisations or companies or any other non-human entity cannot inherit under the rules of intestacy. The deceased must have explicitly named such organisations in a valid will for them to receive any assets. The exclusion of these groups kind of highlights the importance of writing a last will and testament. If you wish to leave a part of your estate to someone who is not a recognised heir under the rules of intestacy, a will allows you to specify exactly how you want your assets distributed, including partners, stepchildren, friends, foster children, in-laws, and charitable organisations. Ultimately, a will provides peace of mind. Not just for you, but for the people you love and are close to. It's about minimising the stress on your family during what will undoubtedly be a very difficult and tough time, and ensuring that they have the guidance they need to make informed decisions without additional burdens. So when we talk about the importance of having a will, we're really talking about taking responsibility for our lives and the aftermath of our passing, ensuring that our legacies are preserved exactly as we intended. Despite this importance, there are plenty of myths floating around about wills. Now let's clear up some of them, shall we? Myth 1. Wills are only for the elderly. As much as we might like to believe otherwise, life is unpredictable, and having a will is crucial regardless of your age. You never know what tomorrow will bring. Myth 2. I'm not wealthy, don't need a will. Wills cover more than just large bank accounts. They're about making sure your personal items and responsibilities are taken care of according to your wishes, no matter how large or small they might be. Myth 3. I can just tell my family what I want and they'll sort it out and they'll honour it. Verbal agreements are not legally binding for the distribution of your estate. A will provides a legally recognised document that clearly outlines your wishes, reducing the risk of family conflicts. Myth 4. Creating a will is expensive and complicated. While professional legal advice can be expensive, creating a basic will doesn't have to be costly or complex. There are many resources available, including online services, which can help you draft a will affordably from the comfort of your own home. Myth 5. I made a will years ago, so I'm kind of all set. Life circumstances change. Marriages, divorces, births, and deaths all impact your last will and testament. For example, marriage can revoke any previous will. So it's crucial to review and update your will regularly to ensure it reflects your current wishes and situation. Myth 6. A will can handle all my estate planning needs. While a will is a crucial part of any estate planning, other documents like trusts and lasting powers of attorney can also play important roles in managing your affairs and ensuring your wishes are respected. Now, we've covered a lot of ground today, from understanding what a will is and its essential components to the crucial reasons for having one. We've also explored the implications of the rules of intestacy and debunked some common myths. Now, in a later episode, we will be going over exactly how you go about creating a legally valid last will and testament that can stand the test of legal scrutiny and protect your estate from anyone who might want to challenge your particular wishes. Thank you for joining us today. If you have any questions or thoughts to share, please leave them in the comments below. We love hearing from you and are committed to providing valuable information to a wider audience. If you found this video helpful, give that like button a friendly handshake and hit subscribe to stay updated on all of our latest content. In the next episode, we're going to learn about lasting powers of attorney, or LPAs, and how they can help us maintain control even in the event that we lose capacity. Remember, a little planning today can make a big difference tomorrow. So until next time then, stay safe, stay informed and stay tuned.